So hi everyone, today we have with us Mr. Satyajit Sarna. He is a practicing lawyer in Delhi. He is a 2008 graduate from NLS. And today we'll be talking about the contemporary issues related to freedom of speech and expression. Hi. Hi. So the first question.
So, we have seen in the recent past various episodes. For example, the JNU incident happened, and then the Padmavati scene happened. So, what do you think? What should be the role of these state and non-state actors? Also the state. I mean, if we look at the Perumal Murugan scene where he was compelled to sign an unconditional apology. So, what do you think is the role?
I think that that's an extremely wide question, but the way we traditionally conceptualize the freedom of speech in Indian law is interesting. I think we should go to the beginning. In a sense, our 19(1)A is interesting from a constitutional background because nothing like it existed when it was put into place. If you compare it to a UK perspective or a US perspective of freedom of speech, you will have two very different locations to look at. In the US, and I think that's an example we can use as a counter because traditionally Indian courts have looked at that and said that is not our understanding. The First Amendment is an absolute bar against any legal interference with the freedom of speech. There may be consequences of some variety, but there can't be legal interference. Congress shall make no law abridging the freedom of speech. Under our constitution, 19(1)A is conditioned by 19(2). And 19(2) is again very interesting to look at because 19(2) has 6 defined buckets of law which govern what are legitimate exceptions to the rule that your freedom of speech is absolute. The position being that you have an absolute freedom of speech which is abridged in the following the following 6 legitimate fashions. What is interesting, those fashions of course are national security, for example, defamation, obscenity, etc., contempt. So, if Parliament makes a law regarding contempt of court, if Parliament makes a law regarding national security, defamation, whatever, then those are not automatically violative of 19(1)A. So, therefore, if you look at, for example, our IPC contains sections which have been protected, therefore, against being violations of 19(1)A and constitutionally tested. For example, let us look at criminal defamation. When it was put to the test in 2014 or 2016 by the Supreme Court in Subramanian Swamy's case, it was found to be constitutionally valid, for better or worse. There were compelling arguments for its being invalidated, which I find persuasive. However, their lordships were not minded to on that day. So, 19(1)A is a very controlled right as such. What we are seeing though, and that I think is where our entire debate really starts, is how many non-legitimate interferences there are with the freedom of speech. For example, you mentioned Padmavati. Padmavati is not a legal question. Padmavati is a question of somebody's identities or interests being, to their mind, hurt, and therefore they take a number of actions which perhaps are not defensible at all in law. So, for example, the section of the IPC 153A, which deals with causing offence, is very, very limited. That is to a religious belief for a sect which is understood to be a proper religion. As such, the Constitution has certain tests for these things. So there are cases from the 50s onwards, coming down to the present, to say that not every use of a religious symbol or of a religious character in media or something is offensive. And then, of course, looking at Padmavati's case, the fact that somebody feels that a historical character is somehow offensive to their identity. The depiction of a historical character who they themselves believe exists, while historians may not have given any credence to that claim, it's a very specious claim.
So my question is about sedition. So the history of sedition. So like the Congress party was framed as a political party before the freedom struggle. So the Viceroy called the Congress as a body of seditious babus. To this date, wherein the Congress manifesto comes and it says that we will do away with the sedition clause. So in your view, consider you should sedition as a law exist, as a provision exist? Should it be on the criminal side, on the civil side, like they say? And is a society really that developed, that forward-looking, that sedition as a thing should be totally done away with?
So we're looking at an interesting question there, because what is narrowly within the purview of the section of sedition as it stands now, and of course we could do this with bare acts and papers, and this is just a prima facie sort of conversation, would include in it merely speaking against the state. That is a problematic position. Because, of course, we understand that traditional legitimate bounds on the freedom of speech have always included, shouting fire in a crowded movie theater, inciting a riot, causing, imminent harm to people, clear and present danger. Those classic tests of when somebody saying something can be harmful to another's health, property, peace, and basically the maintenance of law and order. So a man starting to incite a riot, to tear down, police barracks, for example, to storm a jail, those would, of course, cross the bounds. But merely speaking against, a government, or speaking or criticizing the acts of government, it's a fine line, because how are we in the democratic establishment supposed to criticize the actions of governments, of parties in power as governments, of governments beyond parties, of the operation of the state, of laws which are just or unjust, laws which are perfectly validly passed by parliament, frequently are proven to be unjust by the judiciary, by history, are later invalidated by the same parliament a few years later. So having a legitimate opinion on government's operations of law, etc., as such, is something which I would say is protectable. Now, sedition in the current establishment, for example, came up a few years ago in the Kanhaiya case. If you look at the contents of what was said on that day, nothing in that incites violence. Nothing in that incites the abolition, the destruction of legitimately constituted states, governments, etc. There is, aggressive criticism of policies, aggressive criticism of people in power, aggressive criticism of methods in which power has been exerted, all of which I would say are legitimate exercises of freedom of speech.
So you talked about criticizing the government. Now, if we come towards criticizing judge, for instance, the president of Court, and moreover to the doctrine of scandalizing the court. Now, this is something that we inherited from the colonial, right? So, what do you think? Should we done away with this thing? Because if we look at the UK scenario, the scenario has changed over there. They have done away with this scandalizing of the court doctrine. So, what's your take on this? What should be the position of India?
Traditionally, our judges have had restraint. They have often said and the classic formulation of that is, we have broad shoulders. We shrug off, we can shrug off a certain amount of, dissent, disagreement, criticism, all of which is important. If you look under 499 500 of the IPC, it is not defamatory to speak of a judge's judgment. It is defamatory perhaps to say that a judge has taken money, a judge has acted in caste interest. It is not defamatory to speak of a judge's judgment as per se. So these carve-outs have always existed. The difficulty is we leave everything open to abuse when we have very powerful laws on the books which are broadly framed. And that the amplitude of the framing of these sections has left a great deal of uncanalized power in the hands of governments, authorities, the police, judges, and upon the correct, I'd like to say the right moment, the right person putting pressure on say a police station or on an authority to take cognizance of something, on a magistrate to take cognizance of something in a criminal complaint, can have fairly far-reaching consequences. So perhaps the answer also lies in a judicial setting out of when such orders can be passed, when they can't be, and the judiciary has been doing that. It is a different thing that when, for example, political heavies lean on the magistrate in some far-off part of India to issue summons under one of these acts, they do so. We have examples under 66A in the last year of people issuing summons, of magistrates issuing summons. The section was invalidated 2 years ago. Where's the question of issuing summons under that section? And yet it is done. And ultimately, when a summons comes, somebody has to go somewhere. A great amount of pressure, intimidation follows. I think the key also lies in what you had said, that these were framed at a colonial time. The IPC is an excellent statute. Its framing of various criminal laws, till date has stood us in great stead because at the end of the day, those classical conceptions of what is the crime, how is it to be prosecuted, what are the ingredients of the crime, continue to be the same. It is for these, so to speak, these crimes which are neither crime against body nor crime against property. These are crimes against, often, for example, in some of these examples, the state, sedition. Thank you very much. Crime against reputation, defamation. Crime against somebody's, idea of their self or their religion. 153, causing offense. That we come to a position where these things are to be tested. But a lot of these sections could be looked at now and reviewed by the legislature, which is what I think has shown up in recent calls for reform. There was a defamation bill which was tabled by, I think, one of the MPs, Mr. Satyajit, which I believe Mr. Shashi Tharoor also has thrown his weight behind. The idea there being, if we do away with criminal defamation, what are we left with? We're left with the civil tort of defamation. If we can create a civil law to deal with that, that would also be constitutionally valid. 19.2 protects it. But is it unfair to have defamation as a criminal category when the US doesn't have it, when the UK doesn't have it? Most countries that we would choose to compare ourselves with have it. Countries that do have it include, for example, a lot of countries we would not want to be in the same pages with. I believe North Korea has criminal defamation. So as such, the possibilities for reform are there, and it is, in our classical conception, up to Parliament to do it. Not everything needs the judiciary to validate or invalidate it.
So this one's the last question. So as we have seen that the Indian society per se has come to a pass. We have the 377, it's gone. Like you're developing. Day by day, new things are being infused into a society. So in such a scenario, within like 10, 15 years, on a utopian scale, where do you see freedom of speech and expression shall be taken to in India?
I think what I would like to see is less paternalism. There was just 3 days ago, there was a judgment by the Madras High Court about an app called TikTok. Now, when it comes to TikTok, they said no. First, there were directions to ban all downloads of TikTok, directions to union government to consider use of TikTok, and to consider banning TikTok, putting in place some kind of child online protection law. PUBG. Similarly, at this present moment, for example, I think through various circulars of the union itself, there has been an effective ban on a lot of pornographic content online. it has never been a legal position that pornographic content, the accessing of pornographic content, is illegal. So we are entering a space where people are making decisions for the citizen, and whether they are in the executive or the judiciary, some of those decisions need to be looked at. Whether a court can find it, on what basis would a court say ban an entire medium? It is not one video, one piece of content which could perhaps be defamatory, could be obscene, could be seditious, even under the law as it stands now. But the fact that the entire medium has been put out of business. Now this is violated to my mind of 19.1a, 19.1g, so bans like these, which don't necessarily find reasoning which is good in Indian law right now, need to go. So the same kind of paternalism when it comes to content that we consider, the treatment of the citizen as someone who cannot be trusted with a message is the problematic thing here. In the same way that the freedom of speech implies also a freedom to hear speech, the freedom of expression implies that there is a right to access expression. So, from that perspective, when say a PUBG is banned, or a TikTok is banned, or content is effectively removed from the access of people within a geographic area, you have to see what the reasoning for that is and challenge it when appropriate. But when you say utopian, I have to stress that it is on us to bring these utopias about. It is through vigilant defense of our rights, through agitation of appropriate causes, good cases, bringing them to a responsible judiciary, abiding by those orders, that we can move the needle forward.
So your final comment on if should there be more of free speech in order to combat or in order to respond to what you do not agree to, or should there be restraints to them? What's your take on that?
I think, the classical way to put this is the best argument against a book is another book. It is never the banning of a book, it's never the burning of a book. In a more civilized society, ultimately messages, however virulent, however offensive, however downright disgusting for a political basis, for content which is offensive to most right-thinking people, would be combated by other content, by a counter message. And ultimately that has to be premised on the fact that as equals, it is not for me to tell you what is right. It is for me to tell you what I think is right.
Thank you so much.
Thank you.